As I'm completing this series on people who represented themselves at the Supreme Court, it wasn't possible to go further without first answering, where do we get that right? It's giving us a lot of responsibility.
As the trial court cogently said in this case, to Faretta, quote, I have seen more people who represent themselves convict themselves, where if they just sat down and let somebody who knew what they were doing do it, could well have won the lawsuit.
The key case is Anthony P. Faretta v. California, a 6-3 decision from 50 years ago. Faretta stole a Chevrolet Nova from a house in Long Beach. In his pre-trial period, the judge initially allowed Faretta to act as his own attorney, but then presented a challenging quiz which he did not pass. Until this point, courts in California had rejected self-representation, even in one death penalty case where the defendant wanted to replace his attorney who had been found incompetent. In 1970, the Supreme Court established a right for the defendant to be present in their trial, Illinois v. Allen. Then in Maybury v. Pennsylvania, they rejected an overly long contempt sentence for 3 prisoners who had represented themselves. Faretta would type his appeal to the Supreme Court. Chief Justice Burger pushed back on the Sixth Amendment, using the text and the word shall.
Clear implication, part of the last phrase, and shall have the right to assistance of counsel.
No, I read it together with the confrontation and cross-examination clauses of the same amendment, which in our view create a right of the defendant to present his own defense.
Then you read shall have out of the Sixth Amendment.
Well, only in the sense that the defendant may elect not to have that which that part of the Sixth Amendment allows him to have if he wishes.
It'd be easier to follow if the Sixth Amendment read, may have the assistance of counsel.
Burger also found it risky for the defense.
The prosecutor might be overjoyed at having a defendant waive counsel.
He noted that the judge and prosecutor must agree for a defendant to waive one of their other rights.
When a defendant seeks to waive trial by jury, he is not permitted to do so unless the prosecutor consents and unless the judge consents. Does that policy suggest something about this case?
Justice White was worried about disrupting the courtroom.
What you're really suggesting then is that he should say to the judge, I want to run this trial. You must appoint me a counsel to help me, but I'm running the show.
Thurgood Marshall and Faretta's lawyer agree that the defendant should be able to proceed with a standby counsel.
You quarrel with, at that stage, the judge saying, go ahead and conduct your defense, but I'm going to leave that lawyer there in case you need him.
Absolutely not. I quite agree that that's what the trial judge should do.
The state of California argued that they were safeguarding the defendant's fair trial.
I submit, Your Honors, that a defendant has no such right. Rather, he's a right under the Constitution to a fair trial.
They also questioned Faretta's capability to represent himself.
Also, a defendant could be under drugs or withdrawal. The attorney for Mr. Faretta said that at the time of the commission of the offense, that the defendant, Faretta, was involved in dangerous drug activity.
During their argument, California went deep on the history.
And under the common law, self-representation was not a right, but was a tyrannical practice enforced by the crown and the kings to ensure victories.
Justice Potter Stewart, who did not speak much during oral arguments, delivered another history deep dive when delivering his majority opinion.
In the long history of British, colonial, and American criminal law, there was only one tribunal that ever adopted the practice of forcing a lawyer upon an unwilling defendant in a criminal proceeding. That tribunal was the Star Chamber.
Throughout this series, I've been consulting an article in St. Mary's Law Journal, which points out that Chief Justice Burger not only dissented, but was so opposed to this decision that he was noticeably hostile to Samuel Sloan, the next non-lawyer to represent himself at the court.
Before you commence your argument, when the court granted you leave to appear in this case, you received a notice, the usual notice to counsel, did you not?
No, I haven't received anything since the time. It was 1 week ago that I was advised that I would be allowed to argue. I haven't received anything.
Nothing?
No.
So an unusual twist, the justices' disagreement over this pro se case, and their opening of state courts to more pro se defendants, may have ended their acceptance and appearance at the Supreme Court. Sloan would be the last in 1978. Interest in self-representation tripled in California. Later in 1975, Squeaky Fromme was found competent enough to represent herself after an attack on President Ford, though she later agreed to a court-appointed attorney. In 1999, the Supreme Court would rule unanimously in Martinez v. Court of Appeals of California that self-representation was not a guaranteed right when it came to the appeals process. And in 2013, they established the rule closing the Supreme Court to non-lawyers. The Lodi News-Sentinel reports that Faretta was on parole at the time the decision was announced. I didn't find any reliable information about Faretta's age or what he did after the case. Howard Schwab, who represented California, would later contribute to the state's arguments to keep the death penalty and became municipal judge in 1984. He died in 2016. Jerome Falk Jr., who was appointed to represent Faretta, argued at the Supreme Court 3 more times. In the early 2010s, he was still on cases such as royalties on music downloads and representing the Winklevoss twins at the U.S. Court of Appeals, though they accepted a settlement rather than take Mark Zuckerberg to the Supreme Court. In 2018, his law license became inactive. His name is on a list of retired law firm partners, which was released earlier this year. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.